The Business Innovation Zone, also known as the Biz, is the place to start for entrepreneurs in Iowa. The Biz helps entrepreneurs and startup companies focus on idea development, business models, strategy, market validation, mentoring, and networking. We also help clients connect with qualified community and state resources needed to grow their business. Throughout the year, we provide a number of networking opportunities with experienced entrepreneurs and business leaders by offering monthly luncheons and all-day seminars on marketing and finance. You can learn more about the Biz at bizci.org.
Thanks. I'd first like to thank Mike and the Startup City folks for letting me come here today and talk to you. If you guys have any questions at any time, please raise your hands, interrupt me. I'd rather have a two-way conversation than a one-way conversation. As Mike said, my name is Jason Stone. I'm a senior shareholder at the Davis Brown Law Firm here in Des Moines. My history is as a tax attorney. I have a master's in tax. I started out my practice practicing only tax. Over the years, though, I've decided the tax was too narrow and I like business, and so I moved into the corporate world. I help people form companies. I help people raise money. I help people sell out when they want to exit and do something different. As Mike said, I've been involved with our Startup Launchpad offering. I'm the co-chair of our Emerging Growth Company group. In connection with that, a few years back, we decided to take a different track and start up the Startup Launchpad. Startup Launchpad's built on a couple basic premises. The first is that a lawyer with 1, 2, or 3 years experience is not the same thing as a lawyer that has 10 or 15 years experience. What you're paying when you hire a lawyer is for the experience, not just for the license. But the problem was those lawyers that have a lot of experience, like Rush, they're expensive sometimes, and when you hired them, they might delegate down to associates, so you weren't getting what you thought you were getting. The other thing it's built on is the premise that all documents are not the same. A document that you download from the web and you get for free is not the same as a custom-built document that, say, Rush puts together for a buy-sell tailored to your particular situation. It's about the same as buying a suit from Kmart and getting a hand-tailored suit from Savile Row. So what we did is we took a look at all the legal delivery service process. We said, here's some inefficiencies, here's how we can eliminate those inefficiencies and make this process a lot smoother. So ultimately it resulted in a website where our clients can come in and get some free information. They can also request particular documents for flat fees in most cases, and then once they do that, it has a back end where the process, we have document automation services and other things that kind of speed up our work. It doesn't change your interaction with us anyway, but it speeds up our work and makes us able to kind of lower the price and speed up the delivery process. What Mike asked me to talk about today was business formations. Really what that is, in my mind, is kind of putting into practice what Rush said. I mean, the big picture is what Rush just talked about. This is the mechanics of what he talked about. Usually when my clients come in and they want to start a business, the first thing they want to talk about is what type of entity should they start up. But I think there's a preliminary question before that, because very few people just kind of all of a sudden wake up and say, I want to start a business. Most people are engaged in some activity at the time that they decide they want to start a business. They may be an employee somewhere, they may be an independent contractor for other parties. And those create some issues. First, from an employee standpoint, probably when you have your idea, there's a period of time where you can't just walk from your employer. You need the revenue from your salary. And you certainly don't want to get fired when you start up your new business. And you have to be very careful looking at your employment policies, looking at your employee agreements, if you have an employee agreement, to make sure that what you're doing, whether it's at night or on the side, isn't in violation of those agreements, because they often are, and you do run a risk if you're engaging in activities on the side of being fired if your employee doesn't know about it, finds out about it, and is upset. So you need to look at the policies, the agreements. You often need to talk to your employer to make sure that you don't have any issues there. In addition to that, you also have to worry about IP concerns. If you're an employee, if you're engaging in the development of intellectual property in the course of your employment or using your employer's tools, what you develop, even if it isn't at the request of your employer, may be owned by your employer. And if you then go try to start a business with that, you can have serious concerns. It could impair your ability to raise capital. It could result in a lawsuit from your prior employer against you. So you need to be very careful about looking at that and making sure that what you're doing is not in the scope of your employment. It's not using your employer's tools. Otherwise, you may have some serious IP issues. And then finally, you really need to make sure that you're not going to get sued. There are a number of cases where a person had a bright idea, they left their employer, they went and started their new business, or they went to join a new business, and either the new business and or them got sued. And that lawsuit could be because they violated an independent or intellectual property agreement that they signed. Often employers require employees to sign confidentiality and invention assignment agreements, which kind of back up the base theory that what you develop in the course of your employment is your employer's, not yours. And if you try to take your IP away, then they may sue under that. You also have to worry about non-solicitation. Non-solicitation policies and agreements are common with employees where, for example, with the non-solicitation, you may agree at some point to not solicit other employees to join you. So if you have 2 or 3 guys that you want to break off and do your own thing, if you start talking to them while you're still employed, you may very well be in violation of that agreement. If you have customers at your current employer that you want to use in your new endeavor, if you start talking to them before you quit, you may in fact be in violation of non-solicitation agreements. And those agreements can extend past the time that you're terminated or you terminate your employment. So you just have to be very, very careful about that. You also have to worry about trade secrets. Trade secrets, if you've signed a confidentiality agreement, those are used to protect trade secrets. They're different than patents, they're different than trademarks, they're not filed. It's important and valuable because it's secret, only we know about it, the formula of Coke. There have been a number of lawsuits involving people that have taken those trade secrets to a new employer or a new company and then got sued for stealing that trade secret. In fact, you can even have a criminal claim for stealing trade secrets. There was, I think, a Goldman Sachs employee that not too long ago was criminally charged for taking algorithms from Goldman Sachs to another company. So you have to be very careful about that. Contractors, independent contractors, life is a little bit easier. The rules are different than they are for an employer-employee relationship. With an independent contractor, the assumption is the exact opposite when it comes to IP. Items that you create while serving as an independent contractor are assumed to be yours and not the person that hired you. So that eases that concern slightly. Also, some of the duties that run back and forth between employer and employee just aren't present. But that doesn't mean that you don't have any concerns whatsoever. You have to look at your agreements. Usually, if you're an independent contractor, you have an independent contractor agreement, and you need to be concerned about what those say. It's not uncommon to have independent contractor agreements that have, for example, conflict of interest statements. They say that under no circumstances will you engage in an activity that is in conflict with what you're currently doing for your current employer. They also often have confidentiality provisions in them that say, you know, what I give you as far as information, you can't use or disclose to other people. And so that can significantly limit, like it did in the course of the employee, what it is that you can do. And then they also contain, less frequently, but on occasion, non-solicitation provisions and non-competition provisions, just like the employment agreements do. So you have to look at those and make sure that you're okay. Okay, so once you've kind of determined that you can actually start a new business, your current engagement, whether it's an employee or an independent contractor, is not a problem, then you really have to start looking at what the first question is that we usually get, which is, what type of entity should I really think about starting? Our clients, they really fret. Mike keeps yelling at me to talk louder, so I'll try to do that. Hopefully the mic's picking me up. Our clients really fret about this decision. It's amazing to me how much time and effort they spend before they even get to my door trying to figure out what type of entity they should be. I mean, I really think that they think that I'm going to laugh at them if they come in with the wrong ideas, and the venture capitalists are going to run away from them, and the IRS is going to put them in jail if they make the wrong choice. And it is a very important choice, but it's not one to focus on significantly. That's my job, that's the accountant's job to try to help you out with. And honestly, there really isn't a right choice in every situation. And so even if you make one, nobody's going to laugh at you or tell you you're crazy. And if they do, you probably ought to just ignore them. I think the start to any sort of choice of entity determination really ought to be sitting down and trying to understand your business and where it's going to go. You need to understand the facts and the assumptions that underlie it. And for example, Mike, I think he does the startup models. That'd be a great place to kind of build out, this is what I think my business is going to do from a revenue standpoint. This is the assets that I'm going to need to operate my business. Here's the profit that I'm going to generate. Here's what I'm going to do to raise capital. You need to know, or at least have some idea of what those factors are to actually determine what type of entity you should choose. After you've kind of done the basic legwork, then you can go in and try to examine what some of the factors are that go into choice of entity. And the factors that I principally rely on are limited liability, taxes, the flexibility, and the cost of formation. Kind of going through those one by one, limited liability is an important factor. There are basically two types of entities in the world. There are those in which the debts of the entity can be collected from the owner's personal assets. And there are those in which the debts of the entity generally cannot be collected from the assets of the owners. And those I call liability shielded entities. And the most common types of entities we see today are LLCs, S corporations, and C corporations, and all of those are shielded entities. And so at the end of the day, the liability concern or factor isn't usually a deciding factor. You need to make sure that you get into one of those entities, but once you're talking about those three entities, it doesn't really tell you which one of the three ultimately is the best. If there is kind of one that stands out above the others, it's maybe an LLC for two reasons. One, there are cases throughout the history of business entities where the liability shield for a corporation or for another entity is voided by the courts. And one of the reasons that they void that is because the owners don't respect the separateness of the entity from them. They don't respect the formalities, they don't have meetings, they don't keep minutes. And so the courts basically say, if you're not going to bother doing that type of stuff, we shouldn't let you stand behind that liability shield. We'll let somebody void that, go after your assets personally. Limited liability companies, the formalities are significantly lower than they are for a corporate model. And so that does lean a little bit towards the corporation. But honestly, it's good practice to do it anyway. And I think in a courtroom, there's probably not going to be a lot of difference in application. I think this is a decision that ultimately is one of gut by the judges. So I think it's just a slight preference to limited liability company. The other thing that makes a difference, if you go back to Rush's presentation, he said one of the concerns that you need to be aware of relates to an owner having some liability. Let's say I have 3 owners and one of them is bankrupt. Not because of what's going on at the entity, but personally they get sued and they have a big judgment. If the judgment creditor gets a hold of their equity interest, and that equity interest in stock, they get control of everything. They get the financial interest that that person has, and they get the control or voting interest that they have. So suddenly this creditor of your partner has a say over how your business operates. That's not true with an LLC. With an LLC, if someone gets a hold of, if a creditor gets a hold of that interest, they just get the financial rights unless you agree to give them more. So there's a slight preference in favor of LLCs there as well. But overall, not a big deal. The next one is taxes. C corporations is kind of the older and more common type of entity to start with on that. C corporations are subject to tax. They generate $100 worth of income. That $100 worth of income is subject to tax at the corporate level. Then if they decide to distribute what's left after paying their taxes, then the owners have to pay tax on those distributions. So there's two levels of tax with a C corporation. And those two levels of tax can increase your effective tax rate to over 50%. So every dollar you bring in, you may end up with less than 50 cents to use to build your business or to spend it on something unrelated to your business. S corporations and LLCs, however, are not subject to entity level taxes. They are accounting constructs. You determine your income, you report your income, and then you allocate it out to the various owners. Currently the top individual rate for taxes is 35%. So your effective tax rate should, in an S Corp and an LLC context, be 35% or less. And so there's a material delta there that favors LLCs and S Corps when choosing entities from a tax perspective. But there's a couple other things that I think you need to think about in connection with taxes. One is, aside from income taxes, you have to deal with employment taxes, self-employment taxes. LLCs, more or less everything that flows through an LLC is going to be subject to self-employment taxes. In an S Corp context, the only thing that gets subject to self-employment taxes would be your salary. If you pay yourself a dividend in addition to your salary, you can avoid self-employment taxes on the dividend. And so that can be a useful tool. So kind of wrapping back from a tax perspective, the advantage is to an LLC or an S Corp. If you're concerned about employment taxes, slightly to the S Corp. If you're not too concerned about employment taxes, then LLC works out pretty well. Third factor is flexibility. LLCs, well, let me step back. Corporations, the corporate statutes are older statutes, and they take a different view. They're very paternalistic. They shall say, you shall do this and you shall not do that, and I don't care what the deal is between the parties, this is what we're going to say the deal is. An LLC statute it's a newer version of the law. It takes a slightly different track. It basically says that here's what we think the deal is, but you guys can agree to modify it however you want. So it's a freedom of contract. If you go into an LLC structure, you can basically do, with very little restrictions, whatever you want. You can set up your management however you want. You can set up your reporting however you want. But with a corporation, you're locked into a particular operating structure and you don't have a lot of flexibility beyond that. So that flexibility can be useful in a lot of situations when you're trying to deal with your partners or an investor, and so probably a little advantage to LLCs over either a C corporation or an S corporation there. One of the problems, though, with that flexibility is that flexibility often breeds complexity. LLCs are much more complex to set up. And so if you come into me, you're going to pay more to set up an LLC than you are going to a corporation, because a corporation, we don't really have that many choices. This is the deal. This is how it's set up. With an LLC, there's just a large number of choices to make, and so it takes more time to work through those. Also, from an operating standpoint, I think LLCs are more expensive to deal with. The tax laws that govern LLCs, while they don't pay tax, the tax laws that govern them are extremely complex. And if you're going to bring money in, they're even more complex. And so from an operational standpoint, I think you can see an uptick in your costs with an LLC over a corporation. So cost probably favors the corporation a little bit, both on formation and operation. Some of the common choices that we really see today are, as I said, LLCs, corporations, and S corporations. To give you a kind of a construct of what people are doing, I haven't looked since 2009, but in 2009 I looked to see how many entities were formed, and there were about 8,500 LLCs formed in the state of Iowa. There are about 2,000 corporations formed in the state of Iowa. So clearly LLCs are kind of the new thing. If you go through those factors, you can see a number of the factors kind of weigh in favor of them. So we're certainly seeing more of those today than anything else. But You know, that doesn't mean that LLCs are the automatic choice. I mean, there are a number of problems with LLCs, particularly in the startup context. You know, the first thing that I think you need to think about is that VCs. A lot of people say they're going to want to raise money. VCs don't often like to invest in LLCs. Venture capitalists raise a decent number of their dollars from nonprofits or from pension funds. And those pension funds, because of complex tax rules, are not very favorable to going into LLCs. And so if you're actually going to go out and raise some venture capital money, an LLC might not be a very good thing for you to do. When they can kind of invest in an LLC, they still don't even like to do it because it gets complex for them and expensive. And so, again, the LLCs aren't so good if you're raising capital. Employee equity is tough too. A lot of our clients end up offering some sort of equity to their employees in exchange for their services. And you can do that in an LLC context, but the rules of the road are not very clear at this point. And the complexity behind what we think those rules are is high. And so it can be much more expensive to provide employee equity in an LLC context than it is in a standard C corporation context, both from an accounting perspective and from a legal perspective.
I'm sorry, did you repeat that? More complex in an LLC context than
C or S. Okay. Yeah. And also, raising capital really gets more complex, I think, in the LLC context. So anyway, at the end of the day, LLCs are great. They're more common, but in the startup context, you know, there are some considerations that you need to take into account in choosing. I think that LLCs are probably a little bit overused. If you go back to the primary detriment of a C corporation, it is that it has 2 levels of tax. But 2 levels of tax really isn't going to be much of a concern if you're growing your business, because, you know, everything that you're making, you're plowing back into the business. You're probably not generating a lot of current profits. You're generating a lot of capital gain and appreciation over time. Okay, things that may affect the choice of entity in the future. I think there are a couple things that are on the horizon that we really need to think about when we're choosing an entity. The first one I have listed down is the individual tax rates versus the corporate rates. There's significant pressure in the United States to decrease the corporate tax rate. The U.S. corporate tax rate is much higher than its peers. At the same time, we have a revenue issue and there's significant pressure to raise individual rates. And if that occurs, if we see corporate rates fall below individual rates, then I think we'll see a move from LLCs and S corporations into C corporations because the current tax rate will be lower in the C corporate model than if it's passed through the individual. So for example, if they lower the corporate rate to 20% and they increase the individual rate to 40%, at least on a current basis, by using a C corporation, you can keep your tax rate at 20% as you move forward, as opposed to pushing it up to 40. The second one is Section 1202 of the IRC. That's the Internal Revenue Code. There's a special provision within the Internal Revenue Code that deals with taxes for C corporations. It's for qualified small business stock, and it's a complicated definition. If you're under 50 million in assets, you may qualify. But what it does is it excludes a portion of the capital gain that you generate from the sale of your stock from taxable income, as long as you've held that stock for 5 years. So for example, if you set up a C corporation, you build it up, and in 5 years you sell it off, and that deal is a stock deal, you don't pay any taxes on that transaction under 1202 if you're a C corporation. The exemption has ranged from 50% to 100% over the last few years. There's a push to push it, it's currently at 50%, but there's a push to push it up to 100% and make that permanent. If they do that, I think you'll see a lot of people moving over to the C Corp because they'll hold the income in and pay at a low rate while they operate, and then when they sell out, they don't have to pay tax. So it's a pretty good deal.
What type of expenses would we expect? Right now I'm an LLC.
Right.
To switch to a C or S Corp, what kind of expenses?
It's really easy. It's actually filing a simple form with the IRS.
Repeat the question.
Oh, I'm sorry. The question was, what sort of expenses should you expect if you want to convert an LLC into a C corporation? And the answer is really not much. I think technically what you need to do is file an 8832, which is about a one-page form with the IRS. There can be complications like anything, though. If you have, with an LLC, you maintain capital accounts. I don't know if you're familiar with those, but if in fact you have a negative capital account, you may have some tax liability on the conversion, so you need to hire a lawyer or an accountant to go through that to make sure that it's not a problem. But assuming it's not a problem, the process is very easy. Of course, once you do it, you're stuck. It's very easy to move usually from an LLC to a C Corp. There can be some real tax problems going the other way, so you wouldn't want to make that choice lightly. But it is possible if the world changes. The final thing that might change it is crowdfunding. The Jobs Act contains a crowdfunding provision. It was signed or passed by the Senate. It's expected to be passed by the House today. I expect them to talk about it later today. If it's signed into law, people will be able to raise capital for their entities through crowdfunding. And because of the mechanics of partnership tax, which is applicable to LLCs, and because of the way S corporations work, I think you have a significant pressure to move towards a C corporation if you're going to be crowdfunded. If you have 100, 200, 300 or more shareholders, working through those partnership tax provisions is going to be quite expensive. Not so much so if you're a C corporation. So,
excuse me, Jason, could you expand on what crowdfunding is?
Sure. Yeah. I can. Crowdfunding is a concept of, well, I don't want to kind of move into the securities aspects of what people are talking about later today, but securities laws are very onerous, and raising capital is very difficult. And people have said that there needs to be a better way to do this. And one of the better ways, supposedly, is to allow people to make small investments in entities, with the theory that if they're small, then if they're lost, it's not the end of the world. And so we can do that and not worry about fraud or other things like that as much. So this act, to the extent it is signed into law, will allow you to go out, raise $10,000 or less in most cases from a number of people, thousands if you want, although your total amount raised, I think, is $1 million, and do so on a relatively easy basis. So that's crowdfunding. And what crowdfunding results in is just more owners. And going back to Rush's, he didn't want you to have any partners. Just imagine going from one partner to 100 partners. There are concerns there, both from a legal standpoint and from an operational standpoint. And on the operational standpoint, taxes can really get tough. So I think that ultimately you're going to have some concerns.
So does that lower the limitations? And typically the SEC is like the level of savvy an investor is, and their net worth, and so on and so forth. Was crowdfunding allow the bar to be lowered to where the common, I'm going to say the common person, somebody who's not a high net worth, maybe they make 50, 60,000 a year and they want to invest with that crowdfunding, then allow for a person?
Yeah, potentially, but I don't want to spend too much time on crowdfunding because I assume that the guys that are coming in this afternoon are going to cover that in great detail. So, yeah, my point is just if you do want to use crowdfunding, that's going to be another factor that pushes you away from the LLC towards the C corporation. At the end of the day, it's not an easy choice. I ask about 40 or 50 questions when I talk to my clients trying to figure out, what type of entity they should choose. And you just need to go through that process and make your best guess. Another thing that you need to be concerned about are name issues. This is a common issue that we incur with our clients. They think because they registered their company's name with the Iowa Secretary of State on their articles of incorporation or certificate of formation, that name is theirs. They can keep anybody from under the sun from using it, and they don't have to worry about anybody suing them for trademark infringement. That is wrong across the board. When you set up a new entity and you pick a name, you need to do a little bit more due diligence. Obviously, you need to have a domain name and do a little research there. You also need to think about foreign registrations. The Secretary of State's operate on a state-by-state basis, so it could be that you register your name here in Iowa, but then you want to operate in Nebraska later. If you want to operate in Nebraska, you're probably going to have to register to do business. You may have some issues if somebody's already using your name in Nebraska. So that's just one example of why filing with the Secretary of State and forgetting about everything else may be a problem. And finally, and probably most important, are the trademark issues. Filing does not create trademark rights. Trademark law is a separate body of law, and you really need to think about that when you set up a business and choose a name. You can do some searching to make sure you're not infringing somebody else's name, and then affirmatively you can try to protect your name by doing a trademark registration.
Can you elaborate on the difference between a trademark and copyright? I mean, as far as like with the name, I mean, whether to get it trademarked or...
Yeah, trademark goes through, it's the connection of a name with the good or service. It's that goodwill that you're building up. And the process for going through that is a registration. You have to use that mark in commerce. It may be a name, it may be a logo, it may be a color, but it ties your good or service to that thing that you call a trademark. Okay. And the way that you get that is using it in commerce. Then above and beyond that, you can actually file a registration either at the state or the national level to protect your rights in that name to exclude others from using it. Copyright generally isn't used in that context. Copyright is for an artistic work that is broader and bigger than a logo that's connecting a good or service to that logo.
If you operate in multiple states, should you be protecting your trademark or your name in multiple states?
Yeah, if you're gonna, yeah, I mean, what you can do on the trademark side, I mean, the first thing you're gonna wanna do is, if you're not gonna hire a lawyer, you can hire a lawyer, they can do the work for you, but if you're not gonna do that, the Patent and Trademark Office does have a website that you can search and try to see if there are names that exist similar to yours. And if they are very similar to yours and they operate in the same industry, you need to be concerned about it. That's one thing. Then you can go beyond that and you can hire somebody else to do a search. They actually go into the Patent and Trademark Office, search the files, they do a bunch of related searches, produce a report, then you can look at it, the attorneys can look at it and decide whether you're okay to move forward. That's the protective measures. Then it's kind of moving to the positive, and that's the filing. You can file at the state level for a trademark. If you file at the state level, your rights are limited to that state. If you file at the national level, then your rights are national. And so, you know, in today's age, you know, very few people operate solely within a single state. And so in most cases, it does make sense to file at a national level so that you can protect that name across the country. Yeah, there is a cost, and that's, you know, always the concern, right? I mean, I have limited dollars, and where do I spend them? But as a lawyer, I can tell you that there are a number of situations where we have somebody starting up businesses, choosing a name, and getting a cease and desist letter, you know, 6 months later after they've dropped some good money into the marketing, got some traction, now they lose all that. So you do have to be concerned about that, and it may be a good expense. I would, at the very least, say do your searches yourself to try to look for another person that's...
But then don't you trademark it under like different categories, or
yeah.
Is there any rule of thumb as far as... Because I just filed one recently, and I think it's like $550 per category, but there's a gazillion categories.
Right. I'm not a trademark attorney. I have IP attorneys that I rely on in my office. Emily Harris, who I work with extensively with startups, I usually rely on that. But I mean, generally, yes, the more the better, right? I mean, but you have to tie it to your particular good and service. You can't just say, I might, you know, 100 years from now go into this line of business and try to register under that.
What about history? I mean, we operate in about 6 different states, and we have in most of them for several years without, I mean,
without any registrations.
We're filed, and the research was done, you know, 6 years ago. But we've been using that name for many years.
Yeah, use of the name. If you don't have a trademark isn't created. Trademark rights are not created by the filing necessarily. I mean, you have a concept of a common law trademark, which just a simple use in commerce may grant you those rights. The other issue you have is business registration. If you're operating in another state, it's very common for people to fail to register to do business in that state. And if you fail to register, that can create a concern. First, You could have fines that accrue if you're engaging in business in another state but not registered there. Second, from an investor perspective, it's usually top and center on the due diligence report, and if you haven't done it, that sets off a red flag, or at least something that needs to be addressed before you raise any sort of capital. So, okay. Kind of moving on, once you get your entity choice, once you get your name, you got to split the pie up. And we're running out of time, so I'll move kind of quickly and hit the high issues on this. You need capital to operate, and that capital comes in two forms. It comes in the human capital form and the financial capital form, and it's amazing to me how many of our clients focus entirely on the financial capital component. They come in and say, okay, we're going to fund the entity with $1,000. You put in 500, you put in 500, we'll get 50% of the pie to each of us, and then we're good. But the problem is a lot of businesses don't really rely heavily on financial capital. What they are driven by is human capital, the services that the founders put in, either before they set up the entity or after they've set up the entity. And failing to account for that is a significant problem. On the front end, if you have services that have been rendered prior to the time that you form your entity, those services can create individual rights in intellectual property and other things that aren't owned by the entity, and you need to make sure that those are transferred into the entity so that the entity has those rights that accrued before it was formed. And then moving back to those services that are rendered after the entity is formed, you need to find a way to deal with situations where you have founders who don't really live up to expectations. You were going to do X, Y, and Z over the next couple years. You lose interest, you walk away, suddenly you have 50% of the pie on the expectation that you were going to do X, Y, and Z, but you didn't do it. What do we do now? It's not fair that you own half the company, the other guy's out in the weeds. What we highly recommend to our clients is that where services are an important component of the business, and those services are going to be rendered after the company is formed, that you would go in and vest those founders' units or stock. It seems a little bit counterintuitive to say, hey, I may, as a owner, lose my stock if I don't stick around and do what I said I was going to do. But that's really the best way to make sure that people render the services that underline the deal. So you really need to think about, I guess my message is, think about the human capital. Don't just focus on the financial capital. And if some of that capital is rendered after the entity is formed, think long and hard about vesting the initial founders units so that if they don't do what they say they're going to do, they lose them. If they do what they say they're going to do, they get to keep them.
How can you do that without making it really subjective? Like how do you say you have to do X, X, and X? If
Yeah.
you do that, you're out. But it seems like, especially
Tough.
if it's a service.
Yeah, that's why most people actually default to just time. They vest over time, so at least they're around, kind of employed by the entity over a year, over 2 years, over 3 years. But we do have clients that they'll vest based on revenue matrix, or they'll have a list of this is the deliverables that you're supposed to do, and when you do those, you'll get time. But it is tough. You need to sit down and think long and hard about what are those triggers going to be for those units or stock vesting. So. You also need to think about additional funding. It's very rare that the money that you put in day one is the only money that you need. It may be a couple years before you're able to round up some institutional money. You may need some more money from the founders, and so you should address that up front while everybody's getting along. What are we going to do if the company needs another $5,000 and one guy has it, the other guy doesn't? You need to have your documents address that. We see a huge number of disputes over that issue. We see a number of businesses falling apart over that issue, so you need to think about it up front. Contracts too, we also see a lot of problems with contracts. Before the entity is formed, somebody enters into a contract. That contract needs to be assigned over to the entity so that the entity has rights under the contract, and you need to understand that if you enter into a contract before you form the company in your individual name, that just assigning it over to the company is not going to eliminate any sort of liability that you had under that contract for at least that period of time that it was in your own name, and probably, frankly, forever. Buy-sell agreements, I think Rush is exactly right when he went through those. I am a huge component of focusing on the exit. If you focus on the exit in any contractual or business arrangement, then all the rest becomes less important. If you have a good way to get out of the arrangement, then everything else is just a little less important. I don't need to spend 1 million hours trying to negotiate who gets to approve what level of expenditure if everybody is comfortable that if we just cannot get along, you can go away or I can go away, and we're comfortable that when I go away or you go away, that we're all going to be happy and get a fair deal. So kind of wrapping up, I guess what it comes down to is forming a new business is very complicated. There are a lot of things you need to take into consideration. You need to make sure that you don't have any existing obligations that prohibit you from doing what you want to do. You need to make sure when you go to an attorney or accountant to choose what type of entity that you're taking into account all the factors that should be taken into account of. You need to get comfortable with that choice and understand that ultimately, there's no right or wrong answer. You just need to make a choice and move on. Once you've done that, you need to make sure that your name's in good shape and you're not going to get sued 6 months later for violating somebody's trademark. You need to make sure that you get the assets that are being used in the business over into the business's name. If services are a key component to what is being provided by the founders, you need to think about how to make sure those get done, and if they don't get done or delivered, what that means. And you need to think about the exit, long and hard, because as Rush said, there are a lot of disputes that arise, and if you don't have this, you're going to be paying a lot of money. So, any questions? Okay.
I have a quick question. What's your advice about operating from a business standpoint in 2 different states?
The question was, what is my advice from a business standpoint in operating in 2 different states? Okay. I'll give an answer and then come back and ask you another question, if that's okay. Legally, you first need to, every state does say if you engage in business in my state, you need to register to do business in my state. And each state has a different definition of what doing business is. But if you have assets, if you have employees in a state, there's a very high likelihood that you're engaging in business in that state. And that means you probably need to register. As I said, if you fail to, you can have some significant downside if you just don't get around to that. Once you register, though, the Secretary of State usually talk to the taxing authorities, which means then you better start thinking about filing taxes in that state as well. So that's the legal construct. Now, I'll come back and say, from your question was from a business construct, what is my advice? So can you clarify that question just slightly for me?
Well, sure. I mean, the question is it sounds like it's overly complex to actually set up like an office out of state outside Iowa. So from a business standpoint, can I still if with my startup, could I go and knock on the doors and say, hey, sign up with my startup? I mean, that would be considered business, right? Because it's the same as if I was having a business meeting, in California, correct?
Sure. I mean, and that really goes to what does it mean to do business, right? And I think I can't really address that perfectly because the rules are different from state to state. Having said that, generally if you're reaching out from Iowa and calling somebody up on the phone, or you have a website that's available to somebody in another state, that's generally not going to be doing business in and of itself. It really does start to get problematic, though, when you are putting employees in another state, when you have assets in another state. So before you do that, you might want to think about it, because it does create tax issues. I mean, once you start having assets or employees in another state, that state's going to say, we now have a moral connection with you strong enough to start independently taxing you. And so that's where things get a little bit tough. Also, if you have employees in other states or operations in other states, you just have to start dealing with the laws of those states. They, may govern certain of your activities, and so that gets more complicated as well. But, the world is small. You're going to operate in more than one state. You're probably going to operate in more than one country. So you just need to try to manage that risk the best you can.
Kind of a corollary question. In order to file to register
I believe that's correct. The question was, for the record, to file a trademark, you need to have some interstate commerce. I think you can file an intent to use to start. Again, I should just shut up because this is not my area, it's my coworker's area, but federal law generally covers interstate commerce, so that's probably correct.
So to finish the question, then, would that mean you need to register in a second state to do that?
No, I do not. The question is, do you have to register to do business in another state to file a trademark? And I don't believe the answer is yes.
Can you repeat the name of your partner that does the trademark?
Emily Harris. Yes. We have 4, but she's the one that I usually rely on. Any other questions?
When you say assets in another state, we have contracts with properties in other states we do business with, but we don't have any assets other than, I mean, technically the contract is owned by the company here in Iowa. Just the fact that we are engaged in commerce with them, does that
Usually not.
Situation to register? Okay.
Yeah, the question is, if I just enter into a contract with somebody in another state, does that rise to the level of doing business in that other state? And the answer is usually not. Usually it has to be more than just entering into a contract. Now, having said that, there are states that are more aggressive than others, and if you have the choice, it's probably better to say this contract is governed by the laws of the state of Iowa and it's entered into, you know, in the state of Iowa and that type of thing. So you don't even have to worry about.
And that's already, okay.
Yeah.
All right. Thank you very much.
Yeah, thank you.